puntual.
Vamos a empezar antes de que llegue.
Sí, no hacen para. Entonces, para casi no poner planos generales. ¿Está listo? Sí. Maestro de ceremonia está listo. El plano abierto con esas 4 personas que están al frente. Y yo me abro. Veo a Carlos Betancourt. Aquí tiene el mapa. Dime. Pasamos más adelante cuando ya tengamos una gente. Porque ¿quién da la orden? Ya. Ok, señores.
Iniciemos. Damas y caballeros, muy buenos días. Bienvenidos al Palacio de San Carlos, sede del Ministerio de Relaciones Exteriores de Colombia, al ciclo de conferencias Compliance, Anticorrupción y Cooperación Internacional. El evento que hoy nos convoca pretende aportar y fortalecer conocimiento requerido y contribuir con un nuevo saber enfocado a desarrollar capacidades académicas y de
En nombre del gobierno del presidente Iván Duque, agradezco a la World Compliance Association, capítulo Colombia, a la Academia Internacional de Anticorrupción, al Centro Internacional de Derecho Corporativo y Económico, a la Agencia Francesa Anticorrupción y a la Embajada de Austria en Colombia por la organización de este importante ciclo de conferencias, que sin duda contribuyen a reflexionar sobre los retos, desafíos y acciones que deben implementar los Estados para luchar de forma efectiva contra este flagelo. Me es grato hacer mención a los esfuerzos que ha impulsado Colombia para contribuir en este importante propósito a través del fortalecimiento de la diplomacia y la cooperación. En ese orden de ideas, hemos ejercido un liderazgo en los escenarios multilaterales para prevenir y luchar contra este fenómeno y propender por el fortalecimiento de las políticas de transparencia en la gestión pública, en todos y cada uno de los procesos y acciones del Estado en su conjunto y en la relación con los ciudadanos. Nuestro compromiso se ha materializado en la promoción de escenarios de discusión innovadores y de intercambio de buenas prácticas, como la sesión especial de la Asamblea General de las Naciones Unidas sobre corrupción, la cual busca fomentar el diálogo entre los Estados para robustecer el marco normativo a nivel internacional sobre el cual se fundamenta la lucha contra la corrupción y su efectiva implementación. Somos conscientes de que la corrupción representa una amenaza para la estabilidad y la seguridad de nuestras sociedades, pues no solo socava las instituciones, sino los valores democráticos y pone en riesgo el desarrollo sostenible de las naciones, así como la preservación del Estado de Derecho. Estimados asistentes, infortunadamente, la corrupción es un delito que permea todas las esferas y ámbitos de la sociedad, impactando de manera directa el capital social, perpetuando los ciclos de pobreza y afectando especialmente a las poblaciones más vulnerables. En este sentido, y sumado a los esfuerzos en los escenarios multilaterales, resulta necesario que los Estados actualicemos las herramientas nacionales mediante las cuales estamos combatiendo la corrupción y sus diferentes manifestaciones, en particular haciendo especial énfasis en los ejercicios de rendición de cuentas que permitan fortalecer la credibilidad en las instituciones y fomentar una relación más cercana entre el Estado y los ciudadanos. Durante su mandato, el presidente Iván Duque ha presentado proyectos de ley encaminados a contrarrestar la impunidad, fomentar el principio de transparencia de la función pública y promover la cultura de la legalidad, la corresponsabilidad, la integridad y el adecuado manejo de los recursos públicos. En ese marco, me permito destacar la promulgación de la Ley 2013 del 30 de diciembre de 2019, a través de la cual se obliga a los altos funcionarios del Estado a publicar su información de bienes y rentas en el Sistema de Información y Gestión del Empleo Público y a registrar también conflictos de interés que puedan presentar en el ejercicio de sus cargos. Quisiera finalizar mencionando que estamos llamados a coordinar esfuerzos integrales que permitan no solo comprender el fenómeno de la corrupción en toda su dimensión, sino orientar nuestros esfuerzos para aumentar la transparencia y el acceso a la información, la presentación completa y veraz a la ciudadanía de indicadores de transparencia, incentivar la producción de conocimiento y facilitar el reporte y la denuncia de presuntos actos de corrupción. Muchas gracias.
I now leave you with Mr. Carlos Betancourt, Chairman of the Colombia Chapter of the World Compliance Association, who will act as moderator of our event. Very good morning, everyone, and thank you very much to all those following us online, as well as to the panel with me here today. For this first lecture, we have organized a conference on compliance, anti-corruption, and international cooperation global strategies. There exists a great international consensus around the pressing need to strengthen democratic regimes by encouraging economic and social development of peoples and to promote the advent of an increasingly stronger civil society. However, in a context of radical and fast economic change and technological innovation, the operation of democracy and the market can encounter as a hurdle the traditional structure of state agencies, the precarious public management structures adapting public policy, as well as the obsolescence of legal frameworks. Corruption is one of the biggest hurdles for any state or states to modernize their structures and efficiently comply their new role in society, and in particular as regards the economy. A global phenomenon that has evolved and has become increasingly sophisticated, and we cannot define it or conceptualize it in a single direction given the various classifications of its various forms and manifestations. States have to deal with the necessary modernization of their structures and to develop joint strategies to combat this phenomenon that is a mutual, global, international concern because of the seriousness of the threats to democratic values such as integrity, justice, and the rule of law in itself. So, in an effort to strengthen the collaborative efforts for the prevention and combating corruption on the basis of equality and reciprocal benefits, as well as in line with the laws and customs reigning in the various countries, as well as international law, cognizant of the need to promote together prevention and combating this scourge by developing international cooperation, as well as the joint work in the identification of the main threats and institutional gaps common to all our states, and in furtherance of the integrative perspectives to combat them, we have with us Mr. Diego Cabezuelas Sancho, who is joining us from the city of Madrid, and he is with the Círculo Legal Lawyers Buffet, as well as international president of the WCA. So, Mr. Dr. Cabezuela, welcome and thank you very much for joining us today.
El audio, Diego, por favor.
Please unmute your microphone, Diego. We cannot hear you at this point.
Señor Diego, ¿podría, por favor?
Mr. Sir, could you please activate your audio? You are muted. Yes, can you hear me now? Can you hear me now? Yes, we hear you loud and clear, so. Sir. Yes, Diego, we can hear you. Very well, then. So I will start all over again, and good afternoon to everyone. Madam Vice Minister of Multilateral Affairs, Madam Ambassador of the EU, Ambassador of France to Colombia, and Dean of the International Academy, Anticorruption, and Chairman of the Colombian Chapter on Corporate Responsibility and Corruption, Chairman of WCA, Diego Betancourt, my dear friend. Hello, everyone. I would say that corruption is a global problem, and therefore any strategy to be adapted must be global as well. Regretfully, the corruption cannot be combated with legal tools only or regular political tools, because corruption is the result of greed, poverty, and starts when you have a full stomach, and this is something we should never forget. And I would say that 1% of the world population has 50% of global wealth, and by 2030 that 1% will actually hold up to 64% of the world wealth, then meaning that we are moving farther away from solving the problem than solving it. So many of the problems that can be solved must lead us to improve our law and improve this terrible scourge of corruption. Every country has its own national domestic corruption, big, small. You have it in Colombia. We naturally have it in Spain as well. But I would say that the most harmful corruption is that which is exported or is imported. And this is seen in the major corruption scandals witnessed in recent years and decades that involves many leaders of both government and companies, and promoted by foreign companies. And we see that foreign companies are bribing local government officials. So we need international agreement and consensus, as well as mechanisms for the prevention of corruption. And these must be powerful, and also to establish an agency that should have the ability to enforce them at all times. And in the international scenario, it's very difficult to combat corruption, because sometimes we see that there are bribes in country where bribes are not a crime. And so we need to have a legal structure that allows us to resolve the situation. Now, in combating international bribery, we see that the U.S. enacted its Foreign Corruption Practice Act back in the 60s as a result of the Watergate scandal, while we have seen the technification of international bribery as a crime and created clear causes, thus holding accountable the people that would engage in these practices. And almost 20 years elapsed until we see a true global position on this problem. And then we see the emergence of international agreements that call on states to include corruption and international corruption in their criminal codes. And what is even more important from the perspective of effectiveness, besides introducing all these codes, is to hold accountable the legal entities who should have in place controls that are increasingly rigorous. And this is this is what gave life to the Code of the OAS, or the OAS Agreement, dated 1966, and then in subsequent years, and then 97, 2003, Africa 2003, as well as other equally ambitious tools, for example, the anti-corruption of the OECD, and naturally the European Council decisive criminal agreement and other agreements involving international corruption and bribery. And I think that the entire world has seen the need to combat organized corruption, and that is why compliance has become so important and is guiding the various companies in the United States, besides the wonderful president of the 1970s Act, which is the Foreign Corrupt Act. In 2002, they published, as you know, the Barnes law, which imposes for the very first time in America a series of prevention plans that are mandatory not just for them but their affiliates all over the world. And this had a multiplying effect in Europe, because in Europe there existed and there are still many multinational companies that have affiliates throughout Europe. So this law leads many European companies based in countries that had no criminal responsibility for companies and legal persons, and this allows denouncing and reporting corruption, and this is what years later led to the final implementation of compliance programs. And in this regard, I believe that the UK, for example, has played and is playing a fabulous role, because this is a law that combats corruption and requires acting aggressively as regards the legal code, and it punishes not only the events perpetrated by British subjects but also by non-British subjects outside the UK, provided there is a company that has some type of interest in the UK. Hence, the British jurisdiction has given a global reach to this law and assures great coverage throughout the world. And on top of the seriousness of this and other laws that have been enacted and will continue to be enacted in coming years, there is one that I wish to underline, and it is the international organizations that have a decisive importance in massification of international trade. I'm talking about the work currently done by the World Bank, which is a sort of big brother with money. If there's no transparency and legal compliance, projects will not be financed. And if they are not financed, there will be no contracts, and companies won't engage in business. Now, there are many, many companies operating outside these countries and have been awarded major contracts, and therefore are forced to resort to special funding by the World Bank or through their governments, and there is a World Bank integrity unit that can lead to their being summoned by a legal system on counts of corruption. So I believe that many entrepreneurs who think that could defend themselves against a legal action or judiciary action than finding themselves immersed in a World Bank administrative procedure that can lead them to be excluded as a company that will no longer operate in the market because they will be left without World Bank funding. Now, back in 2007, 2008 in the EU, many Spanish entrepreneurs as well as clients from our legal firm started to look at emerging markets, particularly in Latin America, Colombia being one of those countries, who thought that they would have to compete in a market under different conditions, and that could lead to certain corrupt situations, and that there are other operators that were not from the EU or the US and could have laxer legislation on bribery than in their own countries. But in this respect, let me say that what they have told me is that they found a surprising transparency thanks to the arbitrary work done by the World Bank and putting people on black lists, thus preventing them from receiving World Bank funds or funding. And many companies have cooperated with this position. And this has no doubt been a means to persecute corruption and prevent corrupt acts in certain parts of the world and countries, particularly in Latin America. I would also like to say that this has been done not just by the World Bank, but there are other global organizations who signed a reciprocal agreement with the World Bank to exclude from the group any contractor or operator who has incurred in any form of corruption, which means that the scope is practically global. The African Development Bank, the Asian Development Bank, the European Development Bank are a good example of all the agencies who have followed the World Bank suit and has become a overseer of compliance all over the world. I know I have a few minutes left, and obviously I don't want to exceed the time allotted to me, so thank you very much, and I will conclude my remarks at this point in time. Thank you very much. Thank you very much, Diego, for joining us today and for presenting your views and perspective of international cooperation in combating corruption through compliance as a tool, as a mechanism that is modern and will support not just governments, but the private sector as well, the academia, which is very important too, and jointly advance in respect of this phenomenon that is, as you said, a phenomenon that is unique to a single country but affects us all, and we must therefore move forward together in combating corruption, and to do so together. Corruption is a plague, a persistent plague that has many corrosive consequences on society and undermines democracy, the rule of law, and gives rise to human rights violations, distorts markets, undermines the standard of living of people, and allows for the flourishing of organized crime, terrorism, and other threats to human security. The UN Convention Against Corruption is an achievement in itself that is supplemented with another historic tool, which is the UN Convention Against Organized Crime. Transnational organized crime, and this is a well-balanced, solid, pragmatic tool that offers a new framework for effective action and international cooperation, introduces a complete series of norms, rules, and regulations to be applied by all countries to reinforce their legal regimes and also regulations aimed at combating corruption. So this convention requests that preventive measures be adopted and to identify the most frequent forms of corruption both inside the public and private sectors. Nonetheless, its implementation becomes a bit more complex regarding this topic, and that is why we are honored to be accompanied by Vienna, by His Excellency Mr. Thomas Stelzer. He is the Dean of the International Anti-Corruption Academy, an academy established back in 2010, and contributes a strategic view on how to support all the interlocutors combating corruption, states, civil civil society and private sector by contributing not just a perspective through education, but also technical cooperation. So, Mr. Stelzer, you are welcome, and thank you for joining us in Bogota. Thank you very much, Mr. Chairman. Allow me to thank the Colombia chapter of the World Compliance Association, the Ministry of Foreign Affairs of Colombia, and the Austrian Embassy to Colombia for organizing this very important conference together with the International Anti-Corruption Academy, IACA. We are humbled by the fact that the first high-level event focusing on compliance and combating corruption, international corruption, is dedicated to the role of IACA and strategies for combating corruption. Allow me now to initiate my remarks by referring to the international framework as well as the activities for combating corruption, and to provide you with certain academic data. I would say that Sustainable Development Goals acknowledge, explicitly recognize the link between corruption and peaceful, fair, and inclusive societies. Since 2016, we have viewed bribery as something that requires strengthening institutions and access to information, but also with their peers in achieving the 17 SDGs. And that is why the activities to combat corruption are an intricate phenomenon that is transversal and multifaceted. Corruption undermines human development and deviates public funds for the delivery of essential services and basic services, and it also increases inequalities and hinders the economic development of the nation and regions by distorting the goods and services markets and undermines the rule of law and destroys citizens' confidence in their governments and rulers. Therefore, it is of paramount importance to strengthen institutions as well as the systems for combating corruption, thus facilitating the enforcement of the entire 2030 agenda. And this can only be achieved if we create viable frameworks for international cooperation in the field of combating corruption by helping, in particular, to enforce the UN Convention against corruption. The main legal global framework is prevention and combating corruption. One of the vital areas of international cooperation is actually education, training, and research in the area of combating corruption. And the IACA has contributed significantly in the last 10 years and is willing to open up to more opportunities to cooperate and partner to increase its ability to disseminate the anti-corruption knowledge. IACA is unique. It combines the characteristics of an international organization and a higher education institution, and thanks to this, it can provide a bond between diplomacy and the academia, thus increasing its ability to contribute considerably to the global war on corruption. There does not exist another international organization centering exclusively on combating corruption through education, research, cooperation, and the provision of technical assistance. In compliance of its mandate, the IACA strives to supplement the work done by the UN in the area of inclusive sustainable development. The IACA delivers education and training in the war on corruption to public and government officials, as well as the academia, professionals, as well as the media and civil society organizations. Our ultimate goal is to assist future managers of the international system, including diplomats, as well as civil society leaders, the academia, as well as private sector company managers to acquire the knowledge to safeguard the compliance standards and understand and combat corruption. The academic activities focus in particular on facilitating, strengthening the legislation as well as institutions and practices in a country against corruption, as well as to improve good governance and to promote the production of anyone reporting corruption and protect the integrity of organizations, thus increasing governance and integrity of corporations as well as compliance standards. We have also worked on the recovery of assets as well as combating asset laundering. And the AICA is an anti-corruption research center, and we are convinced that research is a key element that will in the future nurture other academia activities, and the IACA will become a repository for anti-corruption research worldwide, and to create an institution where all anti-corruption authorities, states, and organizations that are party to IACA, as well as observers and others. And finally, the IACA has created platforms for dialogue and establishment of networks among national and regional institutions, think tanks, as well as research centers, and through its team of faculty and international researchers, because we want to strengthen our ties with IACA partners and develop new alliances and partnerships with other states, national institutions, and groupings, as well as research and education centers worldwide. Ours is a global organization, and IACA also acknowledges the importance of regional efforts to combat corruption. Therefore, we decided to start partnerships with specific regions. Naturally, Latin America and the Caribbean is one of our priority areas, as well as other regions in the future, and we have been cooperating very closely with the multilateral organizations of the region, such as the Organization of American States, as well as with governmental agencies like and NGOs such as the Institute for Human Security for Latin America and the Caribbean in Brazil and SHARC. And we've also interacted with specific countries in the region and with their official agencies and institutions such as their higher courts, the judiciary, as well as financial control agencies and the Prosecutor General's Office and Attorney Generals. We have organized several activities to develop different capabilities, including our emblematic regional programs in Argentina and Brazil, among other countries. And one of the modules of our master's program on anti-corruption is in Brazil. And we have also delivered several training programs tailored to the needs of the region. To date, over 200 professionals of the region of Latin America and the Caribbean have participated in various training programs and graduate programs of the IACA, and only 8 of them are Colombian. Nonetheless, we do hope that once we increase our educational activities, a larger number of Colombian professionals will attend our training programs. They must to adhere to IACA and become a member of IACA, together with Honduras, Mexico, Brazil, and other countries, as well as Peru, which is a signatory of the agreement, would definitely assure a more active participation of Colombian nationals in the various activities of our academy. And after adhering to the academy, Colombia could actually participate in decision-making processes inside the organization and tailor the platform to their needs and priorities, which includes education and academic programs. And to be a part of IACA also facilitates cooperating in academic activities as well as capability development, and to offer Colombia a powerful platform for promoting its experience and activities against corruption. And this will surely contribute to consolidate Colombia's profile as a very important actor in international efforts against corruption and to eradicate corruption. And I am convinced that the role of any activity to develop capabilities as well as education and research programs in combating corruption will continue to grow in the future. And in particular, I do hope that the special session of the UN General Assembly against Corruption, UNGAS, this year will be of pivotal importance. Therefore, greater interaction between Colombia in these areas would prove beneficial for all its partners. The very important role played by Colombia within the framework of the UN Anti-Corruption Convention would help promote a program between Bogota and the IACA, and I do hope that we will be able to establish a dialogue on what we can do together and what are the specific needs of Colombia as regards anti-corruption activities, and how the IACA could actually help Colombia to achieve its international policy objectives in the area of combating corruption. And we could undertake joint initiatives pertaining to the implementation of the 2030 Agenda for Sustainable Development within the framework of combating corruption, which could include training programs and other activities that are interesting to Colombia and other countries. And therefore, we could actually use the mechanism, the funding mechanism of the OECD, together with the list of international organizations eligible for OECD assistance. And we hope that Colombia and other Latin American countries and OECD countries will use the mechanism to support the various IACA activities. And among the various initiatives that the IACA hopes that Colombia will support, it includes the project for providing specialized training in the area of anti-corruption legislation to least developed countries, to thus accelerate the implementation of the IACA programs together with its partner countries. The initial activities of these projects have been conducted already in several African and Asian countries. Nonetheless, in the future, and if we have the required funds, these could also be replicated in other continents, particularly in Latin America. A program of activities that I believe could be developed could include initiatives in the main areas, which are academic programs, research, as well as activities for developing capabilities and institution capacity building. And together we could cooperate in various training IACA modules, as well as other graduate programs focusing on civil servants and working in legislative, regulatory, executive agencies, as well as judiciary institutions. Furthermore, we could develop courses to combat corruption to be delivered through universities or regional education institutions, with a purpose to educate all those who are or will be involved in anti-corruption activities, including the enactment of both laws and policies. Now, as regards research, the IACA will try to cooperate with external partners in various regions of the world, and we could consider organizing joint research activities focusing on matters of common interest. Whenever possible, we could actually invite representatives of the private sector from the regions to join this research cooperation effort. And finally, the IACA is interested in cooperating with Colombia in a very broad series of activities for developing capabilities and institution capacity building by tailoring courses to your needs. And we also offer these courses in various formats and languages, some of which are in Spanish. And they have been designed to offer learning opportunities to professionals and allow them to improve and enhance their knowledge and adapt it to their schedules and pace. Allow me to close by saying that I hope that this lecture is the beginning. This conference is the beginning of a new phase in IACA's participation in Latin America and the Caribbean, and I also hope that Colombia will become a very important actor in the process. The IACA is at your availability as regards any initiative for the prevention and combating corruption at a national, regional, and global level. And I hope that today's debate will be very fruitful. Thank you very much for your kind attention.
Thank you very much, Mr. Stelzer, for joining us this morning in this presentation of the International Anti-Corruption Academy, the possibilities that it offers to its member countries, and not only member countries, but also all those that may want to participate in the training courses and education and technical capabilities being offered by IACA as an organization that accompanies the different states and the different NGOs in implementing or supporting the implementation of UNCAC, the United Nations Convention Against Corruption. UNCAC is the United Nations Convention Against Corruption. I apologize. In this series of conferences that we have organized and which we are beginning today with this outstanding panel, we wanted to underline, out of the World Compliance Association, the importance that can be identified in the education and professional education and update in the different aspects having to do with fighting corruption and the consolidation of transparency, integrity, and ethics, all of them key tools to the development and consolidation of the rule of law. So in this first conference, our aim has been to make special emphasis on the integrative perspectives of the different sectors and corners and areas of civil society and the private and public sectors in their fight against corruption. And we have been looking at this new initiative offered by IACA starting September 2021, which is training in diplomacy and anti-corruption practices. We have invited today, it is our honor to have with us Her Excellency Madame Michelle Ramy, the French ambassador to Colombia, and Ambassador Ramy will be giving us her approach regarding the diplomatic capability that a state has to bet on implementing useful scenarios in this regard, as is, for instance, this type of high-level conferences where member countries of the United Nations may come and strengthen the provisions contained in the Convention Against Corruption. So Her Excellency, Madame Michel Remy, the French ambassador to Colombia, will be looking at the strategies that can stem from diplomacy in order to prevent corruption. And in her own view, the essential factors, the essential elements that a state could have available in combating corruption. So I'll leave you now with Madame Michel Remy, the French ambassador to Colombia. Good morning, Madame Ambassador, and thank you very much for accepting this invitation. Good morning. Good morning to all of you, Madame Adriana Mejia, Vice Minister of Multilateral Affairs, Ambassador Thomas Seltzer, Dean of IACA, Ambassador Patricia Lombard, Ambassador of the European Union in Colombia, dear friends, Ambassador of Austria, Ambassador of Portugal, Ambassador of the WCA, Mr. Diego Cabezuela, Carlos Betancourt, President of the Colombian chapter of the World Compliance Association, and at last, Mr. Daniel Rodriguez, President of the Colombian Commission on Corporate Responsibility at the International Chamber of Commerce. I would like to thank the Foreign Affairs Ministry and also thank the WCA for inviting me to join this high-level panel on such a priority for France and also for the international community. As we heard already, this is a priority issue because we see that the total amount yearly of bribings and corruption may reach $303 billion. That is to say, 5% of the world's GDP. Corruption, as we heard, has negative effects on different spheres. It's an obstacle to economic progress. It hinders free competition. It facilitates organized crime, which is the principal condition, and sometimes terrorism distorts political life through the illegal financing of political parties and election campaigns. It undermines people's trust in their own institutions. It favors informal economy and reduces the willingness to pay taxes. So it weakens states and increases inequality. It jeopardizes the rule of law and political instability. This is a reflection that we all make, and I would like to congratulate Colombia for their commitment on their fight against corruption. Colombia is very active in international forums and shows clear improvements in the anti-corruption indices. My congratulations also for having the initiative of launching together with Peru the next special assembly on anti-corruption. This effort shows the political will of taking action against corruption. You, sir, invited me to describe the diplomatic role and the role of international policies in terms of fighting corruption. What we see here is that the biggest impulse in this fight against corruption comes from the international spheres, with the establishment of high standards in the main international conventions. Starting in 1996, we saw many different conventions, regionally or globally, that shed light. For instance, the OAS, OECD, the European Council, and the famous Convention of the United Nations, UNCAC, which is so dear for us, and I'll be explaining why, apart from UNCAC being an extraordinary convention of the Council of the European Union, the 2030 Agenda, and a whole series of initiatives and instances, as is the European Attorney Generals, the Audience for Open Government. So there are many initiatives like this that show that the international community knows very well that this is a scourge that has to be fought. The role of diplomatics and international policies is key because corruption in a globalized world always has an international, transnational dimension to it. And a state by itself cannot fight this transnational phenomenon. The role of diplomacy is of paramount importance from several points of view. In the first place, diplomats negotiate the instruments, the conventions, the resolutions. And I experienced this personally because from 2003 and 2004, I was one of the French negotiators in the Merida Convention together with Ambassador Thomas Seltzer. He didn't mention that, but at that time, we shared many nights, many months, a lot of time in the United Nations building in order to negotiate this convention, which, in my view, it's a great gain of international community because in 2 years, the international community was able to negotiate a broad convention, a universal convention with a scope that had never been reached before, looking at crime prevention, international cooperation, the recovery of assets. And I must underline that this work has been done under the efficient presidency of Ambassador Héctor Samper, former ambassador and permanent representative of Colombia to the United Nations, who unfortunately passed before the end of the negotiations, but whose work was really wonderful. So this convention was almost universal with 187 members. It's the most ambitious scope. It's really a treasure, what we have. We negotiated the conventions, but on the other hand, we have been able to experience them through the conferences of the different parties that enrich them through resolutions, recommendations, and keep updating them regularly. We also handle mechanisms for following up on these conventions. In the third place, we bring international bilateral or multilateral cooperation to the implementation of these conventions with technical assistance, legal cooperation, the exchange of good practices, the search for financing, and cooperation inside international organizations, the Office of the United Nations for Crime and Drug Trafficking, OECD, the European Council. So we give life to these conventions through these entities. The offices of the United Nations Against Drugs and Crime in Vienna plays a fundamental role, not only through the implementation of the different conventions, but also through providing technical assistance, training, communication campaigns, support to the COP meetings, and it cooperates in the training of the research services and judges and police forces in the different countries. These instruments, of course, have an internal effect because they're establishing standards and rules that countries will be including in their own internal regulations, and is given rise to an effect of harmonization of rights. And it raises the standards level of the different countries, and it allows for judicial and international cooperation in our joint fight against this court. That is corruption. Yes, it's true. There may be some limits there when corruption is a systemic problem, and we have to look at the exercise of justice and the lack of resources thereof. But with all these instruments, in my view, we're making great progress. Maybe I could continue talking about the internal affairs. It is not enough for us to adopt conventions. States at a national level have not only to introduce the conventions, but also to adopt norms, standards, legal frameworks in order to implement those conventions. France, on its part, in the last few years, has created many independent agencies in order to support justice. Justice plays an important role here through investigations and trials, but it must be supported by the laws of Parliament and also by independent agencies, which are really the additional support that it requires. We have an anti-corruption agency established in 2016, which has a detection and research capability in terms of corruption. We have a high authority for public service transparency, whose main function is to provide probity, integrity, and the model for the different civil servants. This high authority receives the declaration of taxes of high officials in order to detect illegal enrichment and to fight conflicts of interest. So it plays a very important complementary role to justice. We also have an Attorney General's office. It's a national special financial Attorney General's office, which looks at case cases of corruption or financial crime at high level. And apart from this, I think that states in general can add other tools. For instance, a mechanism to protect those that denounce, those that report different facts and that need protection. And we can also give to NGOs an important role, just as we did, in order to resort to justice whenever there has been a case of corruption. They present themselves as victims and they may resort to justice. On the other hand, we imposed on our servants the duty to denounce facts of corruption whenever they are discovered. And we also do awareness campaigns and education in order to create awareness of corruption and to distinguish between corruption and corruption. And it's important to create an ecosystem globally to fight against this phenomenon from all its different angles, which has a very important cultural aspect to it, as well as a mental aspect to it. We have to fight against these mental models. So it seems to us that international fora, together with national efforts, are creating a very effective scheme or model against corruption. And I'm going back here to the conferences of the parties. UNCAC every 2 years meets with its parties in a different country. And every 2 years, resolutions are adopted concerning new topics. For instance, in 2019, in the Abu Dhabi COP, France and Belgium submitted a resolution about corruption linked to environmental crimes, an innovative topic in the international agenda. And it seems to me that these COP are giving life to these conventions, opening new topics and adopting conventions based on the new needs that arise. So we're generating, this is not hard law because these are recommendations, but this is a legal framework that turns out to be very useful. And at last, I would like to say that I think that international efforts and the work of diplomats and the different international organizations are not only creating a legal framework, which is a compulsory one, but also a political and a moral framework to better fight against this phenomenon. And based on what I know, because I've worked on these topics for many years, what I can tell is that there's been a setback in the culture of corruption. We have seen how it is walking back. Gradually, the economic and social actors have realized what corruption is, that it is not an acceptable practice, and that it can be a crime, that it injures society and public resources. So what I've been able to see after 15, 20 years of work is that there is a setback, there is a going back in this culture. And to me, this is important to realize. And this can generate a domino effect. This is not a beauty pageant, but each country feels involved in this because they can just appear as a country that it does not honor the norms and the standards. And last, I would like to add that some of these conventions have to have a very robust, efficient follow-up mechanism that will actually force countries to be accountable and to provide reports. These reports are of a public nature. There are press releases. And for instance, in the OECD, the follow-up mechanism is quite severe and demanding. So I think that this greatly contributed to make corruption go back or be decreased. And I think that the beauty of these meetings and negotiations and international fora is the human dimension to them. Because before the pandemic, before COVID, and hopefully after or beyond the pandemic, what happens when we negotiate a convention in person is that this allows us to create personal bonds between the experts representing the different countries. And therefore, this leads to exchanges of best practices. We can compare our different systems. We can establish new cooperation links. And these meetings really create a new fabric of specialists that will bond together the different public institutions, thus making them more efficient in their fight against corruption. Thank you very much.
Thank you, Madam Ambassador Remy.
in sharing your experiences with us. So, following with our dynamic, we would like to look at the perspectives that the diplomatic world may have in fighting corruption. I think that both in the Convention of the United Nations Against Corruption, UNCAC, as well as based on the different recommendations stemming from the OECD or others, reference is always made initially to encouraging societies that will be responsible and to be ethical leaders with principles that will be based in high standards of professionalism, gender equality, cultural equality, that will allow for the consolidation of the transparency and integrity and ethics as tools to develop and to consolidate, as we said from the beginning, the rule of law. We feel that one of these tools, essential tools in fighting against corruption, is indeed transparency. And transparency in itself is a fundamental human right. So here comes corruption as something that cuts across everything, and that is present not only in the agendas of these conventions, but that due to its importance was inserted even in the SDGs. So if we start from the basis that fighting corruption, compliance, modern mechanism, modern societies, strengthening of the rule of law, well, looking at all this, we think that a good tool in order to promote and to strengthen all these items is transparency in our region specifically. This is not exclusive of the Latin American region, but it is true that in Latin America, we have a vision, we have an approach to transparency that may differ from that that is held in other regions or other contexts. So in order to empower our citizens and the media, we will be hearing from the ambassador of the European Union to Colombia, Ambassador Patricia Lombard, who will be showing us the feasibility and the way in which international cooperation may contribute to transparency in political affairs and finance. Madam Ambassador, thank you very much for joining us this morning. On the contrary, thank you very much. And good morning to everyone. Thank you very much for this invitation. I would like to start by greeting the Vice Minister of Multilateral Affairs of Colombia's Foreign Affairs Ministry, Madam Adriana Mejia, and Carlos Betancourt. Good morning, Carlos, President of the World Compliance Association Colombian Chapter, Diego Cabezuela, International President of the WCA, Thomas Stelzer, and I don't know if I'm pronouncing your last name correctly, member of the Foreign Service of the Republic of Austria and of the and of IACA, and my colleagues, the French ambassador, the Austrian ambassador, the Portuguese ambassador, and also my greetings to Daniela Rodriguez, President of the Colombian Commission on Corporate Responsibility and Anti-Corruption of the International Chamber of Commerce, and naturally to all the other people that are present in the room, and also very especially to those that have joined us through the different platforms and virtual media that allow us to have a very high reach. I would like to greet Carlos Betancourt as the president of the Colombian chapter of the WCA and thank him for this very timely initiative regarding corruption topics. So this initiative is in process through last year's launching by the president, where I had the honor and the opportunity to participate. And with this, I would like to reflect on the presence of the second year in this Colombian chapter about the importance that the European Union and the member states of the European Union grant to the fight against corruption and to transparency and the strengthening of public finance, both in our countries as well as in the foreign relationships and our relationships with the other countries, that is to say, in diplomacy and cooperation. And I think that this is very well reflected with the presence of 3 countries of the European Union in these work table. And as we heard before, several of my predecessors in the use of the word in this meeting, this is cooperation that stems from joint acknowledgement, an acknowledgement that we share in that corruption weakens democratic systems and jeopardizes the social contract and also our democratic values, as well as citizens' trust in their own systems. And of course, in countries like the Latin American countries and also in Europe, it hinders a sustained and all-inclusive growth. And it's a burden that, unfortunately, as it happens with all the structural flaws that our societies have, has been increased during the pandemic through corrupt practices in public acquisitions, particularly in the purchase of medications and materials and services, and embezzlement of funds for private gains, and undue use of a particular interest and the needs for help. Actually, the pandemic has not helped in our going in the right direction. But this is a time at which I want to join the acknowledgement and the congratulations expressed by my colleague, the ambassador of France, on the government's efforts in terms of fighting against corruption, efforts that have been led by the president of the country and the vice president. And I acknowledge this leadership from their commitment at the highest levels of the state, which is absolutely necessary. And it is necessary because the index of perception of corruption disseminated recently by International Transparency shows very discouraging results. More than 2/3 of the countries of the world have this burden of corruption at a very high degree. And Transparencia Internacional, international transparency, looks at 4 priority angles for action in order to mitigate corruption. First, to reinforce the oversight agencies. Second, to guarantee open, transparent acquisition processes, to guarantee access to all public records. These 2 are very closely related to strengthening transparency and being efficient in the realm of public finance. And there's a 4th element underlined also by international transparency, which is to advocate, to defend democracy, and to promote the public space. And this 4th point is linked to the obligation that falls on all of our governments to promote that the civil society organizations and the press will act as guardians that will observe, investigate, and ask for accountability from politicians and the business world. And in any of these 4 points, diplomacy and international cooperation play a fundamental role. One first aspect in this fight against corruption and the promotion of transparency refers to the management of public finance. And we speak of both how corruption affects all aspects of management of public finance, but also to the fact that it is necessary to recognize that strengthening public finance management systems is an essential element in any credible program aimed at preventing and controlling corruption. Hence, out of the European Union, we have promoted the good governance of public finance and the promotion of the principles of transparency, 2 pillars of our cooperation with all the countries around the world, with all our partners around the world. And this we do through different mechanisms. One of them, harnessing support and cooperation international European cooperation through a very specific mechanism called budgetary support, which accounts for 40% of the global funds of the European Union in third countries. And here in Colombia, it represents 80% of the funds that we disburse in Colombia. Why? Because this is an instrument that contributes to the strengthening of public finance. What is the reason for it to be able to do so? Because these budget support makes this strengthening initiative and makes the budget transparency two central elements of the interventions that we make in any sphere that we can speak of, be it peace or the environment or any sphere for action. These two elements are very much present in this way to work and to cooperate through budgetary supports that link to disbursements of aid to progress in these two large areas. And in the specific case of Colombia, the European Union and looking at the strengthening the European Union has made the strengthening of the different official agencies an essential part. At this point, we're supporting the building of the Fiscal Observatorium of Resources that will include the Controllership's office, and we will be working with the National Budget Direction for strengthening the portal of economic transparency, and more particularly, the follow-up on public resources invested during the COVID crisis, a topic which is of great interest for all citizens. And in the third place, we're also supporting the design of budget tracers, as is the intent at this point, supporting the wishes and the will and the efforts deployed by the government of Colombia and its different institutions in order to reinforce all these mechanisms of management of public finance and transparency. And during 2021, we will continue along these lines, working with the Controller's Office and the Ministry of Finance in topics such as good governance of public organizations, the simplification of paperwork in order to speed up and smooth out the contact of citizens with the civil service, and to the same time decrease any corruption that may be linked to these different steps. And we will be cooperating with the Unit of Financial Intelligence in order to strengthen the mechanisms against money laundering by making use of the best international practices. Of course, this international cooperation takes place also among the different partners of the international community, and we work together with the Colombian government and other actors, as is the case of the World Bank, the Embassy of Switzerland, the IDB, etc., in order to promote a structured dialogue in terms of public finance, where the fight against corruption and the strengthening of mechanisms of transparency will be central elements. And globally, much has been said about the different topics regarding transparency and fighting against corruption, but these are very much in the agenda of the European Union and the member states, referring to the fight against fiscal havens and the full implementation of the Convention of the United Nations against corruption. We also support the strengthening of systems against money laundering and fight against the financing of terrorism, and also abusive practices of international companies in terms of international fiscality that undermines the capability that countries have to collect taxes. But we also speak of promoting the public spaces, as Carlos proposed in his introduction. And here we're talking about freedom of press and the right to citizens' participation as fundamental pillars in our democratic system of control of power, which is at the heart of the fight against corruption. Civil society, the media play fundamentally three roles. First, ensures citizens' access to information regarding cases of corruption and the reply on the part of government, awareness of public opinion regarding corruption. And this is a key role in order to create awareness in citizens regarding the rights to demand ethical behavior of civil servants and to denounce cases of corruption, but also be aware of their own obligation to abstain from acts of corruption. So here we're talking about civil society as a key role in order to empower citizens for them to demand transparency and accountability. And here, international cooperation plays also a very important role. Out of the European Union, we are also working specifically on strengthening participatory mechanisms for building policies and for fighting corruption. And also to look at different elements. We're working on strengthening the local spaces for participation with the most vulnerable individuals, civic education and mechanisms that are available to citizens regarding specific cases of corruption and denounce of these cases, etc. At last, I would only like to acknowledge the vitality of civil society in Colombia regarding these issues, which was very well reflected in August 2018 in the framework of the consultation against corruption. And even though the threshold was not reached, citizens were pivotal in order to put these topics in the agenda, these topics regarding corruption. One last reference to the media that play such an important role in fighting corruption. Many cases in many countries would have never been opened or known if it had not been for the role played by journalists. In the European Union, we want to call on the media to continue advocating the freedom of press and to the different authorities in general not to spare any efforts in the guarantees given to their activities and protect the rights of the individuals that are participating in the framework of our democratic life. So by saying this, I would like to conclude expressing my thanks again for this opportunity that we've had as the European Union to join you in this very important event. Thank you very much.
Thank you very much, Ambassador Lombard, and thank you very much for sharing your views with us, because you have a very clear vision as to the importance not just of transparency as a tool, but also the importance in society and the role played by the media in this fight against corruption that is very, very important, as you well pointed out, and should be based on the principles of ethics and transparency, which should be the basis of the media. And this is true for technical experts and the media as a catalyzer of this situation and in its interactions with civil society. Within the framework of this conference, we have, as we have said from the very onset, to establish some kind of rapprochement with the three fundamental pillars, which are civil society, the private sector, the public sector, and in this case, its interaction with the international community and the business community. Is obviously corruption and combating corruption in the public sphere with the business community has become ever more visible in recent years, particularly in our region, given transnational bribery that leads us once again to look at this war on corruption from an international perspective, because we know that we cannot do this on our own, regardless of the individual countries' strategies, and no matter how well prepared and trained we are to move forward in this fight. Given our culture and realities, we know that we cannot do this in isolation. Now, to address or to look at this from the business community's perspective, we have Daniel Rodriguez. He is a CMS partner at the Rodriguez Azuero in Colombia, and he is also the chairman of the Colombian Committee on Corporate Responsibility and Anti-Corruption of the International Chamber of Commerce. Daniel will be talking about how international cooperation can contribute to give visibility to these cases and prevent corruption from the private sector's view. So very good morning, my dear Daniel, and thank you so much for being with us here today. Very well then, Madam Vice Minister of Multilateral Affairs of the Ministry of Foreign Affairs of Colombia, thank you very much for hosting this meeting, as well as my deepfelt gratitude to the Minister of Affairs and to my friend Carlos Betancourt, Chairman of the World Compliance Association, thank you very much, and to Diego Cabizuela, World Chairman of the WCA. I would wish to greet the French Ambassador to Colombia, Madame Remis, the Austrian Ambassador to Colombia, Mr. Gérard Durac. I apologize for my pronunciation, and Mr. Thomas Stetzer, the part of the IACA, Dean of the IACA, as well as to Madam Patricia Lombard, EU Ambassador to Colombia. It's always a pleasure to see you and hear you, and to my other fellow panelists who are here today. Thank you, and thank you to all those joining us from all over the world. I would like to start by saying that Colombia signed the UNAC, the UN Convention, the UNCAC, the UNCAC Convention Against Corruption, many years ago, actually, and it underwent the entire procedure that actually ended into the year 2006, and we have made great strides. And I believe that the convention provides a very important framework in many arenas, both in the private sector, because the convention does include a series of instructions and mandates to member countries that are very relevant as regards the private sector, acknowledging that the topic of corruption isn't something that can be understood at the level of public agencies alone, but has to be understood in its close ties with the private sector. And that is true for many other instruments. I'm talking about the Inter-American Convention Against Corruption that also has many tools for cooperation between the private and public sectors. And I would say that as regards cooperation, I would talk more at the level of international cooperation. I have seen that there is sufficient, because if someone were to ask me, tell me of existing instruments undersigned by the government of Colombia and its agencies with both bilateral and multilateral organizations, are those enough? Do they suffice? And I would answer that the problem does not lie in the absence of instruments. And if we would like to ask the following question, is whether these internal tools that I would call domestic law tools suffice in the area of cooperation, I would say yes, because there exist different types of tools. We have penal tools, where we have many challenges to overcome in criminal investigations in Colombia. And here I would like to mention Colombia's experience when it joined the OECD. It showed something that I would like to oversimplify, and I'm oversimplifying a very extensive document, and it is that Colombia has in general, and when its adherence to the OECD was being looked at, it was decided that we have a sufficiently good legal constitutional framework. And that's not the problem, because the main issue lies in enforcement, that is to say, in enforcing existing legislation. That is the quid of the matter. Consequently, of course, it is necessary to deploy efforts as regards regulation. I'm not denying that. I have been a fierce critic of many of existing things because I think that the public policy is not consistent. It is poorly worded. But in general, I do believe that there are sufficient regulatory mechanisms, and we have made efforts ever since Colombia joined the OECD in the implementation of standards that were missing as regards administrative accountability of legal legal persons, because you cannot forget that UNCAC mandates that states implement accountability by legal persons and allows states to determine whether they should follow a criminal or administrative procedure. And Colombia opted for the administrative responsibility avenue, and this is something we've debated at length in Colombia, and I debated this actually yesterday at a forum with dear friends and colleagues, whether the right avenue was criminal or not. But I am convinced that we have made strides, and at one point I had the honor of working with the Presidency of the Republic, and this is with the previous administration, because if you'd like, I am apolitical in the sense that I have no special affiliation with, I've worked with the last three administrations, and in the previous presidency, we did a work that was basically academic and of a legal nature in order to present the government with the advice of an international expert who devotes his life to that, which was to produce a bill on the whistleblowing. And we presented that project, and the legislative agenda was very, very tight. We had the peace process going on. It was submitted and then withdrawn. And this government has submitted a bill currently under the First Committee of the Congress of the Republic, presided over by the Speaker of that bill is Franco Trino, and Paloma Valencia is the Vice President of that committee. And in that bill, the current government, that is the government of President Duque, has presented what they call the anti-corruption package, somewhat late, I would say, because that was justified because of all the other things it had to do. So the government has submitted its anti-corruption package, and in it, it includes the Colombian standard in the area of whistleblowing. And the whistleblowing standards are a series of provisions, some whose purpose is to protect whistleblowers, and there are different types of protections that can be accorded to whistleblowers. And we have expressed very respectfully to the Vice President of Colombia, as well as to the members of the First Committee of Congress in a public hearing that asked us for our views. And I would simply like to say today that in our opinion, for the whistleblowing system to actually have an effect. And what is the effect? Because all we want here is to have, and this brings me back to the first point, which is to have more enforcement, to investigate things, to impose sanctions, and to prevent impunity levels, Mr. Stelzer, that are actually shameful in a country where impunity is so high. So we need enforcement. So part of the report actually presumes that we know the fact that we can investigate facts that no one knows. And enforcement also entails that there are people who have sufficient incentives to resort to the civil service and the judiciary to actually report and denounce cases. So we are convinced, at least from the perspective of a Colombian that loves his homeland and feels that his sons, Jerónimo and Adelaide, would be able to grow in a better country. I mean, I say this openly, that's my only interest in life, for my children to have a better Colombia. And we believe that a very important tool to that end is for these whistleblowing programs to have incentives. An incentive program comprised of, and this is in compared law, we submitted to Congress irrefutable numbers, completely irrefutable, as to the difference of when whistleblowers are acceptable or not. And these are data for the last 20 years in countries such as the U.S., not just Colombia, because regardless of one's political affiliation, the truth is that the U.S. has been, not today, but for decades, the leader in combating international corruption. So when one looks at this type of country, one can unequivocally conclude that whistleblowing systems, when they include incentives, they bring about effects. And what kind of effects? More whistleblowers. And what does that lead to? More investigation. What does that mean? We are investigating corruption. So all I'm trying to say about that is that. Now, I don't know how much time I have left, Carlos. How many more minutes? I have 10 minutes? Okay, perfect. So having said this, I welcome and I invite once again, maybe for the 5th time this week, to the Congress of the Republic of Colombia to give serious thought to including incentives, and the type of incentives are sanctions, for example, because sanctioning incentives include that when a person knows of an act of corruption, it can resort to the authorities. And if this person has participated in an act of corruption, then this person can raise his hand, blow the whistle, and simply say, I have participated, but I have come here to receive benefits as regard sanctions. So with this, what I'm saying, that this is true not just in compared law, where we find some extraordinary examples, but in Colombia itself, we have had examples that for many years were very, very successful. In Colombia, we had not had these popular actions. I mean, those of you who are not acquainted with Colombian law, these are sorts of class actions. These are initiated by someone on behalf of a group and does so on their behalf, thus establishing an incentive for whoever did it, and this was a financial incentive. And it worked in an extraordinary manner for many, many years until a national debate where we had a mafia of people engaged in class actions for money. It seems that someone got upset because they were making their money out of class action. That's when we made the magnificent decision of eliminating financial incentives, and from one year to the next, we saw that a reduction of 77% in class actions in Colombia. What does this mean? That some did not benefit from this, but nor we did not have class actions on behalf of those who cannot do so on their own. Someone has to pay for that. Allow me now to move on to the subject of international cooperation. I believe that in international cooperation there exist sufficient mechanisms in place, both as regards international treaties, bilateral or multilateral, as well as in our domestic legislation. But I also believe that there is still room for improvement as regards the knowledge and training of the authorities in this area. Let me give you an example, because those of us in the world of fighting corruption on the private sector, which are companies who can also be victims, because if there is a civil servant or a government official who thinks that it's a good decision to pay someone to have a contract awarded, the company is usually the victim of this, because then companies are the victims of the desire of the civil servant to find an additional buck. And this is true when the directors and officers of companies who engage in anti-corruption events, and they are the victims, actually. So we have seen that the investigation conducted by the authorities who have more resources, because we have, a public resource issue here, because there are, agencies with less resources, compared to the SEC, the Securities Exchange Commission, who has more money, or the Department of Justice, the DOJ, or the Serious Frauds Office in the UK. And the French authority, let it be said in passing, has made great headway, because the French authority in the area of corruption was not a particularly relevant authority within the framework of anti-corruption. Given recent investigation, it has acquired greater importance, and that has proven very useful. In this type of international investigations, there are a series of agreements between the authorities and those investigated. So you can very well imagine that there is a French company, or a British company, or a US U.S. company that decides that it's a good idea to engage in an act of corruption to simply be awarded a contract. Can you imagine that there is an investigation conducted by the British or French or U.S. authority who have more money than our local authorities, and they conduct a very detailed investigation involving millions of dollars, and then the conclusions come? It is more frequently than what one thinks. You have the deferred agreements or non-disclosure agreements where an institution says what I care about is for you to not engage in more criminal actions but improve your practice because you're a very important company. We want you to continue existing but don't repeat this act of corruption. And in the jurisdictions I had just mentioned, they have the statement of facts, which is where parties agree to reach an agreement around the facts, but these are facts that do not typically engage acts of corruption that can be used against them as if, it were to have a domino effect. For example, in the French authority will investigate an act of corruption in Colombia, and this can be multiplied. But those streaming of facts, which are also agreed under these non-prosecution agreements or deferred prosecution agreements, has very valuable public information, but it's very limited. And I feel in my professional practice that Colombian authorities would have the possibility of having greater cooperation with the authorities because the rules of confidentiality do not limit those international public agencies to cooperate with other states. And that's very important to bear in mind because these issues of confidentiality, even for the investigated company, is very important because it's part of the agreement. I mean, if you reach that agreement, that does not limit. So I'm about to conclude, but let me say that there is a very important input there where poor countries with less resources, third world countries that are trying to make some headway in this regard, we have a lot of serious investigations that we can resort to, in-depth, detailed investigations through international cooperation. And this is relatively simple. And one could have all these significant international investigations on a map, and it goes without saying that the Odebrecht investigation in Colombia, they were all based in U.S. investigations, and I cannot mention others because of conflict of interest in my professional practice as a lawyer defending other companies. But with this, what I'm trying to say, and with this I conclude, is that we have wonderful tools, we have very good inputs, but what is missing is something is missing to get to enforcement, which is to provide greater training, greater visibility, and to make sure that these tools can be used in our conversations with the DOJ, the SEC, and other international agencies to use them in Colombia. So thank you very much, and I apologize for overstepping the time allotted to me, but thank you so much for letting me share my thoughts and reflections with you. Well, thank you. Thank you, Daniel, for sharing your view with us. I mean, the view of the private sector, which is closely tied to strengthening the international cooperation strategies, which is of paramount importance in the deployment and enforcement of this war on corruption, because we've all agreed here today that this is something that we cannot do on our own in isolation, but we have to cooperate. We need to work in a coordinated manner amongst us and with the business community. Colombia is going through a historic moment where it has to assure the implementation of a peace accord that has entailed new social approaches, and it is positioned today as a pillar, an axis, or a center where many countries of the region are looking at and following what Colombia is doing in strengthening its structures and mechanism to combat corruption. The government of President Ivan Duque, our current president, has been working from day one and has turned the fight against corruption one of its priorities, and I've had the wonderful opportunity to work with him and for him to support the Colombia chapter of the World Compliance Association. If we were to summarize this first conference, we could say that the deployment of the diplomatic corps of the international community accredited in Colombia has and we hope will continue to bear fruit in terms of prestige and in the leadership of strategic actions in Colombia. And all too frequently, its ability to, in other countries of the region, to internationalize actions such as those in Colombia. So the dialogue between governments to assure and secure the national interest of Colombia or any other country implementing or strengthening its anti-corruption strategies must undergo or look at the relationship with the other subjects of the international community present in Colombia or having a foreign representation. And today, we cannot say that the fight on corruption, both public and private, can be viewed in isolation, bearing in mind that we are witnessing an increasing globalization that imposes regimes, standards, as well as new international norms and standards, and we must adhere to those, and I therefore share wholeheartedly what Daniel Rodriguez was saying, in the sense that we have the legislation and now we have to work in a coordinated fashion, and we must learn together to implement it in an effective and efficient manner, not just in the macro states of government, but for us to have the ability to bring all the actions we are implementing today and on which Colombia, the region, and the world are implementing down to earth in the territory. So we have to be inclusive in respect of these tools to provide territories or subnational authorities the ability to understand at their level how they can go about implementing these recommendations or opportunities that are being offered by the country's senior leadership. To conclude, we could say that in this fight against corruption, the best internal policy is the foreign policy focusing on strengthening international cooperation and collaboration amongst the various multi-level agencies, and this will inspire us, instead of doing a copy-paste, and to bring to our realities what can be adjusted and to adjust it in the best possible manner. And that would allow us to work for the modernization of our mechanisms in Colombia using our current legal framework and finding inspiration in international experience. And with this, I would like to thank Thomas Stelzer for joining us on behalf of the IACA and UNITAR, Your Excellency, the French Ambassador to Colombia, Madame Michelle Ramis, as well as our dear Patricia Lombard, Ambassador of the EU to Colombia, our dear Daniel Rodriguez, who has joined us from the very start of this meeting. And I would like to say that in the series of conferences, and of course, Diego Cavicer, my chairman and dear friend, who actually allowed the Colombia chapter to be opened up together with the entire WCA team in Madrid and here in Colombia. And I would like to close by saying that this series of conferences that starts today, that will continue through May 18, will end in a publication on good practices and recommendations that from the compliance perspective and in a transversal analysis, we will include the perspective of international cooperation and diplomacy to the fight against corruption, and we will continue making headway. And on April 27th, we will have a next conference from 10 to 12, and we will be addressing strategies against money laundering and compliance, and need to safeguard the culture of lawfulness as well as integrity, attaching emphasis to public transparency and public compliance. So thank you very much for joining us today, all those of you who have followed us online. So thank you, everyone, Ambassador Ramis, Lombard, Daniel, Diego, and Thomas. Well, thank you very much for joining us, and we will be distributing the publications arising from this meeting. And thank you very much for your assistance, and we hope to see you at our next conference. Thank you very much.